You can go right there. We're having it. Court does call the case of People's State of Michigan versus Thomas Styron II.
The moment Judge Simpson announces the case, the tone in the room shifts instantly. We're barely seconds in, and already this hearing carries the weight of multiple felonies, a self-represented defendant, and a judge who makes it clear, today is serious. This opening may look routine, but it sets the stage for a high-stakes preliminary examination where every word matters. Thomas chooses to represent himself, and that alone changes the entire dynamic. Judges are required to warn defendants that self-representation means stepping into the arena with the same expectations as trained attorneys. No shortcuts, no leniency on courtroom rules. And notice something subtle. Judge Simpson lays out the charges with precision. Fleeing police in the third degree, resisting and obstructing an officer, and driving while suspended. These aren't soft allegations. 2 are felonies. This means today isn't about guilt or innocence yet. It's about probable cause. Does enough evidence exist to send this case to trial? For viewers, this is where the intensity begins. Anytime a defendant insists on going without counsel, the stakes rise instantly. It raises questions. Does he believe the evidence is weak? Does he distrust lawyers? Or is he confident in his own ability to navigate complex legal procedures?
Good afternoon, Your Honor. Revokes on behalf of the club.
Sir, state your name, please.
I'm George Styron, sir.
All right. This date time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the Motor Vehicle Code in the third degree. That is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute and constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines, as well as questioning of the witnesses. Do you understand all of that, sir?
I understand everything.
Pardon?
I don't understand everything.
Okay. And, sir, do you still wish to proceed unrepresented? Very good. Do you have any questions before we begin the preliminary examination?
I haven't had a chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the new staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far. I'm able to get through the first
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive. And I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time and evidence to even review it, to be able to articulate it.
This is a critical turning point. Thomas tells the court he hasn't had proper access to the body cam footage. One of the most powerful forms of evidence in modern criminal cases. Think about the risk here. He's representing himself without having seen all the evidence against him. That's like stepping into a boxing ring blindfolded. Legally speaking, this raises fairness concerns. A defendant has the right to review all discovery so they can mount a proper defense. If he doesn't get time to do that, any testimony, cross-examination, or legal argument he offers could be fundamentally weakened. And Judge Simpson knows this. The prosecution even acknowledges that they were planning to add more charges: felonious assault and felony firearm, both extremely serious. Imagine facing potentially mandatory prison time and not having had full access to the videos that might show what happened. That's why this moment matters. But here's the twist for viewers to consider. Is Thomas genuinely unable to review the evidence, or is this a delay tactic? The judge must decide whether this request is strategic or legitimate, and that tension drives courtroom drama like nothing else.
Ms. Hughes.
Your Honor, I understand that the APA that was present before me had intended to admit at some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Howe's testimony.
I guess and I understand that, Ms. Hughes, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, account of felonious assault, which is assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay.
Now the stakes skyrocket. The prosecution just revealed new charges they plan to add. Felonious assault with a dangerous weapon and 2 counts of felony firearm, each carrying a mandatory 2-year prison term. Mandatory means exactly that. If convicted, the judge has no discretion. The sentence must be imposed. For viewers, this is where the tension snaps into high alert. Thomas is suddenly staring at far more serious consequences than the original complaint. The prosecutor's tone here is strategic. Raising the severity of upcoming charges can pressure defendants, especially self-represented ones, to take proceedings more seriously, or even push them toward accepting counsel. But here's another layer. The prosecutor doesn't object to adjourning the case so Thomas can review the footage. That's not generosity, it's smart lawyering. If the defendant later claims he didn't have adequate time to prepare, it could jeopardize the state's case. Allowing the delay protects the record.
And under those circumstances, and I forgot, I think you had mentioned that before, that with that. Okay. So, Mr. Styron, you're requesting an adjournment of the proceedings so you can get through that. Is that okay? How far, and I guess I was unclear, you have access to the body cam?
Yes, I do. It's in my property.
Okay. But then you were talking about you got through some of it?
The first video, and I believe it's a YouTube, not YouTube, but a Facebook video of a bystander.
Say that again.
Facebook video that somebody took.
Okay.
And part of his body, maybe 20 minutes, half hour's worth.
When you're saying his, you're talking about
Officer Hoops, yes.
Okay.
I believe his body cam footage is an hour and 15 minutes in its totality. So I've barely been able to scratch the surface of that.
Okay, let me ask you. Go ahead. Were you going to say something else on that?
And like I said, I believe there's 15 or 16 videos in there total. Maybe more, and that's just what I was able to see.
Okay, so let me ask you this. How are you arranging to view that video?
So originally I was kiting everybody I could. I was correctional services, the sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
Okay.
And he was able to arrange this first meeting. And like I said, I got a kite back from him yesterday telling me just to bother the noon staff, and they'll arrange it during the noon shift. So
Gotcha.
Prior to yesterday, I was still asking. I guess I was asking the wrong shift. I was asking later in the day, that's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay, so you were trying to do it one way, that wasn't happening. You finally got to Flint, and he indicated to you that it's the noon staff you're supposed to bother to try that. Okay.
This segment highlights the gritty reality of jail-based defendants. Access to discovery is a logistical challenge. Thomas explains the struggle: miscommunication, short staffing, difficulty arranging viewing, and inconsistent procedures. To a judge, this all matters. The courts can't expect a defendant to prepare effectively if the jail doesn't facilitate access to evidence. Judge Simpson digs into the details because he needs clarity. If Thomas truly hasn't had a fair opportunity to review the videos, an adjournment is justified. But judges are always balancing 2 competing forces: the defendant's rights and the court's need to keep cases moving. This exchange also reveals something deeper about Thomas. He's persistent. He approached multiple staff members, sought help from different sergeants, and kept pushing until someone finally arranged viewing time. That level of effort contradicts the stereotype that self-represented defendants are careless or unprepared.
Clint's definitely provided direction in regards to how I can go about getting this.
All right. Okay. So we'll need to then adjourn that. Have you, well, I'm going to ask it one or two ways. How long do you think it'd take you to get through it? I mean, how long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it, or is it going to take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by design.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer, and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a...
No, that's fair. That's fair.
Here we see a rare moment of honesty in a courtroom. Thomas admits he cannot commit to a timeline for reviewing the footage because jail access depends on unpredictable factors: staffing shortages, illness, lockdowns, and available viewing equipment. This is the chaos of real-world incarceration, not the smooth scheduling people imagine. From a legal perspective, the judge asks these questions for a reason. He must ensure the defendant isn't stalling, but he also needs to avoid setting unrealistic deadlines that would violate the defendant's constitutional right to prepare a defense. If the judge forces a rushed hearing, any conviction downstream could be attacked as unfair. But viewers should pay attention to something subtle. Thomas mentions that if he were out in the world, he could complete review within a week. That's not just a practical statement, it's a hint toward requesting bond modification, a strategic breadcrumb.
And then also...
But you don't know total time, how much there is. You just know that one.
Since May, I've been fighting an illness that just recently the jail's addressed. So there's so many things going on. I've been since May. I've been having stomach issues, bowel issues, and on Friday or Saturday I was urinating blood. Finally, I was able to get some the medical staff to do something with that as far as me urinating the cup and give me some type of antibiotics. But all they can tell me is I have an infection. They just don't know specifically what type of infection. So I'm also dealing with that, and it's making me very lethargic and
okay, I got you.
Energy in that.
What do we
that as well?
What do we look like on the 6th? Well, we've got stuff. It's a day like today. I got stuff in the morning, but then, okay, so that we hopefully won't run into this again. You've gotten all of the discovery.
Pardon me?
You got all of the discovery. Like you got as far as you know, you got the police report. You have all of that. It's the video. All right. So what I will do is I will adjourn the preliminary examination in this matter. I would go to the 30th, but I think I'll go to August 6th, 2024 at 1. I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you're talking about, short staff, whatever, and you haven't been able to get through everything, talk to one of the deputies so that they can get in contact with my office, so that if we have to push it out another week, we can just get that done without you coming up here and telling me you're not ready.
Fair enough.
Okay.
And a question in regards to is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world. I guess me being put on bond so I can take care of my illness as well as look at this discovery and handle that. So it'll probably be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the jail would hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to run the information against him.
The prosecutor takes a decisive turn here, reminding the court and all of us why bond was originally set so high. This isn't just a fleeing case anymore. According to the state, Thomas allegedly threatened to cook the sergeant and his K-9. For prosecutors, that language is explosive. It signals potential violence, disregard for authority, and a threat to public safety. Now, Thomas disputes this interpretation. He insists he was referring to legal heat, not literal gunfire. But this is exactly why body cam footage becomes central. Tone, wording, and context matter. A single phrase can carry wildly different meanings depending on delivery. From a courtroom strategy perspective, the prosecutor highlights these allegations at this moment because Thomas is trying to argue for bond modification. Their message is clear. This defendant is too risky to release.
Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Haupt took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said cook, I made it very clear. I said it meant legally to get the courts, which he iterated on his body cam. So according to the body cam video, he was fully aware that I meant legally through the court process. And also, I believe in the police report, he was sitting there for a welfare check with a possible wrong domestic, which led me being pulled over. Me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my parents' description, based on who was looking up in his talent or the lane system or whatever it is they use in the police cruiser. Make sure they iterate that I plan to use the legal system to address any transgressions or trespasses I felt was made against me. Also, I was the one who stayed on top of these charges. I'm the one who called the court every day, stayed on top of this case, and I'm the one who arranged the court date with Ms. Fink. I was the one who called the courts week after week, and they didn't have my case in, and finally they did. I was very proactive in trying to get this addressed through the court system. I had no intentions of running or trying to avoid it at all. And I think my actions were sued such.
In this matter, I'm not going to, at this point, change your bond, Mr. Stern, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations. I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least as I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that.
This is Judge Simpson's strongest statement yet. Up until now, he has been measured, procedural, and patient. But here, he makes his position clear. Based on what he's heard so far, Thomas's behavior represents a genuine risk to the community. Judges don't use that language lightly. Even without viewing all the evidence yet, the judge is allowed to rely on the allegations before him, the defendant's past conduct in the courtroom, and the nature of the charges. Bond decisions revolve around two criteria: danger to the public and likelihood of returning to court. In the judge's eyes, this defendant checks the first box, danger. But there's another layer. The judge mentions Thomas's demeanor in previous hearings. That means before today's calmer exchange, Thomas may have displayed hostility, agitation, or non-compliance, anything that raises concerns about controlling behavior outside the courtroom.
Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I ask you to do. This is the first time today, as we were talking to each other going through the things, that it's been a civil conversation with you to try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have, based upon what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom, I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th, and I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. And I'm not saying you're guilty of them. I'm not saying any of that. But in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here. Okay. And so all of that I have to take into and can take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before. And so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay. And I would agree, just real quick, and I'll let you. I would agree with what Ms. Hughes has said, and that is that if your medical were to an extent, our jail is excellent. I have to say the sheriff's office is extraordinary in making sure that people get the medical care that they need. But certainly you would have to apprise them of that, and I think maybe you have, and they will make sure that you're taken care of. I just don't have a doubt in my mind and have never had an issue with an inmate getting the care that they need. So, all right.
Two things. 4 times we've been adjourned because I asked to represent myself. I don't believe my demeanor played any roles in that. I thought it was because there was some misunderstanding as far as the courts trying to represent myself.
Oh, no.
And then in regards to the medical thing, I reported this in May. It took until I got blood in July before anything was ever followed up on or done.
Okay. I'd suggest that you send another request regarding the medical issue. And Mr. Styron, I would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me, because you have a right to do that. And I'm just going to let you know, that is not the reason. You need to go back and you need to look at what you were doing in this courtroom toward this court for reasons I don't even, Mr. Styron, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
What I was saying was, maybe I was misunderstood. That when we went to proceed with the court proceedings, there was some misunderstanding in regards to the public defender's office representing me versus me representing myself. And since there was that misunderstanding, it was adjourned, I believe, 4 times over those matters. It wasn't because I was acted out or anything. I believe I came and went so fast. It wasn't even opportunity.
No, there were a couple of adjournments because of that. Okay. But but that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates were trying to make sure of that. And I was, just to be honest with you, Mr. Tyron, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision just because and not fully understanding what this was, because these are serious charges and there potentially more that are coming. That's my whole thing on that. Okay.
I appreciate it.
This portion reveals how heavily the judge weighs the defendant's temperament and long-term decision-making ability. When a defendant represents themselves, emotional control becomes just as important as legal knowledge. Judge Simpson directly tells Thomas that his hothead moments influence decisions about previous adjournments and the involvement of the public defender. This isn't a judge being harsh. This is a judge being realistic. Courtrooms require composure. When someone reacts impulsively or aggressively, it signals risk. Will they follow orders? Will they appear for trial? Will they escalate outside the courtroom? The judge also highlights a critical point for viewers to understand. Self-representation is a constitutional right, but it's also a dangerous privilege if misused. A defendant must demonstrate they understand the risks, responsibilities, and procedures. If they appear unstable or impulsive, the court must intervene to ensure fairness and safety.
All right.
One last question, if we're about to be done. In order to get a hold of your office, I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information. The jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents or
I'm not, well,
or in regards to me needing more time.
I think you would have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you? Oh, there he is. So he'll figure that out. He'll let you know how to get a communication up to my office.
Right.
Okay.
Yeah.
And not whether or not I can do anything about it, I don't know. So when that happens, so that you understand this, Darren, whatever you send to me that I'm going to review needs to also go to the other side. But what I will do to try to make things easier, if this is okay with the people, is that once it comes to me, I will make sure that whatever you're sending to me, they're going to get a copy.
That works, thank you.
All right, because envelopes are $1 and I have no money in my account, so it'd be very burdensome to try and buy envelopes to send to everybody.
They're $1? Seriously?
No, down there.
I got about $500 in back. That okay. Why? No, I'm just saying, if I can sell it for $1, I'll just take the whole box down. Anyway, okay. So we sorted that out. Make sure to get with them. They'll make sure it gets up to us.
Perfect. Thank you.
Okay,
Yeah.
Mr. Syra, I appreciate you behaving yourself this way because just listen, because you're coming in hot like you did before. I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that, and my only response to that is I've never had that happen. All the other judges I've ever had going front of, whether traffic or Miss Fink that was able to have a conversation after the court time.
She's nicer than I am.
She's a very nice woman, that's for sure. And
She's much nicer than I am.
like I
And
say,
so she has patience. Sometimes I don't.
fair enough.
So you got to take it as it is. All right.
Well, have a good
Thank
day.
you. You do the same.
Thank you.
As the hearing winds down, the final moments reveal the human side of the courtroom. Thomas acknowledges the differences between judges he has encountered, and Judge Simpson responds with candid honesty about his own temperament. After an intense back and forth throughout the hearing, this moment feels almost grounding. Two individuals recognizing each other's flaws and limits. Legally, the hearing ends with several key takeaways. The preliminary examination is adjourned to allow Thomas proper access to video evidence. Bond modification is denied due to public safety concerns and past courtroom behavior. The court acknowledges Thomas's medical claims but defers to jail procedures and staff. The prosecution has hinted at additional, more serious charges still to come. As this case moves forward, the real battle will unfold on August 6th, where the evidence will finally be examined in full and the judge will decide whether probable cause exists for all charges, both current and newly anticipated. This hearing wasn't just procedural. It showcased the friction between constitutional rights, courtroom decorum, and the real-world challenges faced by defendants navigating the justice system from inside a jail cell. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.